when we're talking about child custody and the decisions that a court's going to make about where a child's going to live, almost every factor that we talk about in a divorce is going to be part of that decision. The individual parent's relationship with their children, whether there are siblings involved and how bonded they are to siblings or family members, people outside of the parents and the children. The court's going to consider the home life for each parent. Do they have an appropriate home, a stable home for those children? They'll be looking at things outside of the home, school, friends, etc. The likelihood that a parent will facilitate the relationship with the other parent, that is an important consideration. The likelihood that a parent might move away from Central Ohio or from wherever the case may be taking place, and how likely it is that parent will, if awarded custody, will move to a place that makes furthering that parental relationship difficult. And so all of those things are going to be part of how do we determine where children are going to live post-divorce. I will a lot of times have clients come into my office and say, I'm willing to have shared parenting 50-50, but I want to be the custodial parent. Well, those two things aren't exactly the same. And what it really comes down to is decision making. There's a presumption in shared parenting that both parents are decision makers, that both parents are available to be a significant part of their children's lives, that there's an open discussion about how we raise our children, about the kinds of things that we're gonna do, the big parenting decisions. Shared parents are both considered the residential parent, the custodial parent, when they're exercising their time with the children. So when the kids are with mom, mom's the parent. Mom can make the decisions. Mom has the authority to do whatever a parent would do. When the kids go back to dad, that authority shifts right back to dad. Dad is the parent. Dad has the authority to make those decisions. When we talk about a sole custody context, when someone has sole custody or is the sole residential parent for their kids, that person is really the only person who can make those decisions. The other parent is still the parent. There's no taking that away. But they don't have the decision-making authority that the custodial parent does. And so that's something to consider when we're talking about custody cases. Is this a case where you see yourself being able to discuss parenting freely with your significant other, with your former spouse? Not everybody can do it. Everybody thinks that they can. A lot of people think that's going to be something they're going to be able to do, but not everybody is going to be able to make that work. We'll come up with a shared parenting plan, a written document that they're going to be able to rely on, that they'll be able to use as a framework for those discussions. Here's how we're going to be able to discuss extracurricular activities. Here's how we're going to be able to discuss medical decisions. Here's what we do if we can't reach a decision together. If we are at an impasse, how do we break that impasse? Those are things that we're going to build into those plans.